emails.
Mm-hmm.
Yep. And are you okay with the expectations we set?
Yep.
Yep. Cool. So I guess, like I said in the initial email, the purpose is really face-to-face introductions, getting to know each other, and giving you the opportunity to tell us what you want us to know and for us to actively listen. If you have any questions that you want us to answer and we don't have the answers, we will get back to you, and we can commit to a time frame here today. And if we need to have any other hui, whānau hui, whatever type of hui or discussion we need to have, we can arrange it and set the agenda today too, if that's what you would like. Is there any questions about us that you're wanting to know about our roles?
Well, you guys called the meeting, so we'd like you guys to start. Where do you guys see this going, and how do you see it happening?
So ultimately, we know that the goal on the current court records is that it's a return home goal.
Okay, so going by that, how is that supposed to happen when we've also got it recorded on record that was not happening anymore? Have you guys read the file?
Yes.
Okay.
We're reading the file. There is a lot of paperwork that's been submitted by everybody, as you guys are aware. So in terms of reading everything, I have yet been able to do that, but they've been reading as much as possible.
So going by that, I'd have to assume that you're not up to speed on where the case is at. I can 100% today say I know exactly where the case is at. Okay, and so my agreement on coming to this was the fact that it was written down that you guys would have yourselves up to speed before you came to this meeting. Mm-hmm. And it sounds like that is not the case.
In the email, we also said that we could read everything and we still want to hear from you what you think.
We've already tried to work collaboratively with Oranga Tamariki, with whānau huis and hui whānaus. Okay. My view of the hui of whānau and whānau hui is it's not worth the paper it's written on, simply because your legislation says that the only one you can take back to court is a FGC 128 report. So therefore whānau hui and hui of whānau is absolutely useless, and that has been brought up at the Waitangi Tribunal as well. Okay, so how you were saying about leading forward, I would do that simply based on the fact that having a whānau hui, which we did last time, we had a hui of whānau. And even though the two whānaus agreed, it was the social worker and the lawyer that decided that was not going forward. There are full agreements from both whānau, and yet OT step in and go, this is not happening. We don't care what your advocate says. So, we've basically come here today based on the fact that, okay, we wanted to find out where you guys were going with this, because we do have avenues to pursue it higher than the District and Family Court, and if need be, we will do that. Because in our view, because her mother didn't actually do anything wrong, there has been care and protection concerns sprung forward. The first two had been addressed. So what we would like to know is what are the care and protection concerns right at this stage now that Oranga Tamariki have never addressed. And every time we've asked for it in written communication, they cannot list them.
Sorry, there's a couple of questions leading from that. So the first, you talked about an FGC 128 plan.
Yep.
To be clear, you're talking about two separate things, because we have the FGC plan and then the social work 128 plan.
I know there's the two different. I also know you have a 186 report that gets submitted to the judge.
Okay, so you mentioned when you were talking about that, that the only thing that's valid is the FGC 128 plan?
That's correct. Going by your legislation. Yeah. Okay, and it was brought up to the Waitangi Tribunal. I can't remember the man's name, but I watched the Waitangi Tribunal, and he stated there is no point now whānau's going and doing hui a whānau or a whānau hui, as neither of them come under legislation. Yeah. So therefore, the only ones that a whānau can submit to the court, or that OT can submit to the court, is a 128 plan, and that is the one that is locked in legislation. Okay,
thank you. And then the second question that I had was the whānau hui that's occurred, was that subsequent to the 128 plan being
both were
before the court?
Both the hui a whānau and the whānau hui were.
Okay. And what's your understanding of the reason that the whānau hui came about? What was the purpose?
That was based on the fact that
Because we asked for it.
we asked for it, and then the hui whānau was based on the fact that there was a discharge hearing on, it was either May or June the 5th last year, and we were asked by the advocate to withdraw it out, the application out, because it would go to a hui whānau and more would be able to be collaborated. And that is exactly what OT, we would like to collaborate on this, but to us it became a case of, let's get them to take it out of court and do nothing about it, because that's what happened. We come away from that with nothing.
I'll say something just because I was at that whānau hui. And so I was of the understanding, and this is because the social worker informed me, that this was this was an attempt to be able to make a plan. And what was good about that hui was that both whānau agreed to a transition plan, and we had it all set up and all that sort of stuff. And then when the lawyer and OT came in, it was, we don't think that, we need to take it away, we need to have a meeting. And I went to that other meeting, and it was very clear that there was no return home. There was a reluctance to return home. And I think that's sort of, and then so that plan that everyone had worked on for a couple of hours just disappeared.
Sorry, so to be clear, I completely get what you're saying.
Yeah.
So was the reluctance from OT at the time around the time frames that the family had agreed on?
They were just reluctant on
Or the
anything.
plan?
The whole
Just
thing.
the whole style.
And I think it's also because the time frame actually it was with her returning home by September, so it was a really good amount of time. And this was probably, I suppose, one of the things for me in being part of that was it was really clear that both whānau were working together, and it was the paternal whānau that actually put forward a lot of it. So it wasn't under duress, it was a really good hui, and it was a bit sad, the end result of that. And so I think that sort of underlies some of this relationship as well. From if we're working, because the whānau could have just gone with discharge, that's the thing, and they probably would have been, successful or something, but they could have gone with discharge, but the maternal whānau were like, we'll give this a go. We'll put our all in. So I think that's probably one of the other reasons why it's like, where is Oranga Tamariki going with this case, given the underlying stuff?
And I think you've also got to take into account that when lifted, Emily put in place an S128 plan. Okay, now she did this without any knowledge. Okay, it was handed in on the 16th of April. The judgment was done on it on the 17th of April. In October, we found out the judge never approved it.
It's been filed, but not
The bad thing about it was, you can't turn around and say to someone, I want you to do these different courses, knowing they're a 16-week course, and then say, I'm going to review it in 8 weeks. There's no way the person could complete it.
especially during COVID.
Yeah. One thing I do want to bring up, I'll let you guys have a read of this. This is what I got this morning. Okay, this is from a guy up north who's speaking directly to your regional manager because I can't get past Dean Weebly.
Do you want me to read the whole thing?
Yep.
Read it out.
Just read the whole lot.
Oh, am I reading that out loud?
Yeah,
Oh,
yeah.
I don't mind.
It doesn't matter, either way.
Yes, I appreciate the ministry is bound by the Privacy Act. That's fine. I'm aware that Dean has sent an email seeking confirmation that we will advocate for this whānau. The concern I have is that it is alleged that Dean has expressed advocate to replace the whānau support. If this is true, it's disappointing that your site manager attempts to reduce wraparound support services. For what reason, I'm unsure, as I have never encountered this attitude before at a practice level. Well, at least not this year anyway. 7AA allows for the whānau Kapuiwi to fully participate in planning for children and planning for outcomes for mokopuna at the centre of attention. It also binds the ministry to robust communication. Tikanga Māori law is the guide for which we shall apply this support. If your manager has any trouble understanding this, I believe he will cause serious issues for your region in regards to reducing disparities. I'm sure we can work out a resolution if we monitor the progress. As part of the resolution, I am happy to encourage the ongoing involvement of a culturally appropriate person appointed by OT. Might I suggest within the parameters of section 2091 and 92. Please have someone forward my genuine concerns to me without further delay so that I can begin to plan to mitigate any potential harm for the mokopuna. I'm aware of the medical issues and meetings, opinions from medical practitioners that have taken place. If Bruce is saying is entirely correct, and he has in fact documented the entire process as he claims, I strongly advise he work towards returning on mokopuna by the end of next week before the whole thing blows up in the ministry space. If we have not decided on a return date by then, I will support Mr. Meta in court. We have enjoyed a lot of success recently. Aotearoa, gaining a lot of confidence in new direction resident judges are taking in the north. Therefore, we have set new precedents in the family court while taking this matter to higher jurisdiction if necessary. So that, just for the voice recording, is an email that was sent to
He's an advocate from up north.
Yeah.
He saw the live video, so he made contact.
Is this the initial live? Which live video?
The live video that's at the office from Lower Hutt.
Oh, okay.
Which is what I'm gathering your guys' expectations came from for this meeting.
Not entirely. So we know that this particular case has surfaced on social media platforms continuously.
Yep.
Not just the video recently.
Nothing's been said before that video went up, ever. The only communication we've ever had she's never got judge's minutes in regards to a video, and I know it's in regards to that video because the judge mentioned in there that he was mentioned in the video, which is correct. I did mention him.
Oh, okay, sorry. Sorry. So you're talking about the video
The live we did at the office, yes.
Yeah, okay. So what we know is that this has been on social media before, which is why we set out the expectations.
Yeah. So I'm gathering Dean hasn't made you aware of the one last week there where we were live in the office.
Yes, I was aware of that.
Okay.
Yeah.
So this is where this guy's come from. I did contact him when the uplift first happened, but he never came back to me. But he's seen it, now he's come back to me. Okay. So have members of other...
So one of the questions that you've asked is what are Oranga Tamariki's current care and protection concerns that need to be addressed, and by whom?
Yeah.
That you feel need to be addressed.
Yeah.
Okay. Can we commit to when we would respond to that question?
Well, you should have an answer for that today because they should know what their concerns are. They've had well over 12 months now.
So for that long, and we're still trying to catch up. And I know that there were the initial care and protection concerns at the beginning when the place of safety warrant was.
Yes, the place of safety warrant that was illegally done. Yeah.
Court documents. So we know what those care and protection concerns are, and we do know that there's been the initial psychological assessment that was completed, and there raised some concerns with that and recommendations for further psychological assessment on yourself. Is that what you're wanting to talk about?
No, because the judge has already turned around and gone to a 178 report for us because he knows that under 178 section 2, which is what you guys are seeking and pursuing, and she's already told the judge no, she's not willing to do that, and he apparently knew that she would do that. So he's asked for a report to be able to get where the doctors are coming from on this, because as far as he's only got to decide whether our whānau was right or whether the medical team was right.
Okay. I understand.
Yeah.
My ignorance around this particular subject. What was your reasoning for your non-consenting to the psychological assessment being completed purely on you?
That's all in the relevant email correspondence. I'm not going to be going into that. I've already said no, so that's the end of it.
Okay. So from a legal point of view, we've been advised that without that supporting evidence, creating further plans could become more difficult when we don't have the evidence to suggest that there's safe parenting factors going on or unsafe attachments. we need to kind of get a clearer understanding from a psychological perspective around yourself. I think that's the advice we've been given from our legal.
Can I ask where that advice came from? Was it Rebecca Dean?
Yeah, our legal.
Okay, so Rebecca Dean needs to make up her mind what avenue she's going down, because you cannot select 2 paragraphs from a 178 report, then when you get evidence to support that she's wrong, move to 6 other paragraphs. Okay?
Okay, sorry, can you just be a bit more clear around
So under a 178 report, you get different paragraphs. Okay? Rebecca Dean originally referred to a paragraph 175 and a 162. Okay? When an answer was given in regards to paragraph 175, she then moved back to 162. Okay? When we clarified 162 for her, she now moves to I can't remember the numbers, but there's 6 other paragraphs now instead of 175 and 162. Okay? Basically what it comes down to from a legal perspective, from my understanding of the law, is this. Okay. You've moved with 2 paragraphs. That hasn't worked. Let's fish for others and see what we can get. Okay? The judge has already told them, and I was in the courtroom the last time we went, okay, that he's not going to put up with the mucking around. Okay? It's plain and simple. It's not like everybody keeps saying it's a very complex case. Okay? It's not a complex case at all. What it is a case of you've got a mother who took her child out of a hospital because doctors said that they could not help the child without the whānau agreeing to the treatment. The problem you got was that the treatment had already taken the child downhill for 5 weeks. Okay, when we first of all followed after the FGC what we were told to do in regards to the medical plan, OT's backing, in my view, caused that child to drop 1.2 kilos in 14 days. Okay, and then OT wanted that to keep going, the same plan. Why would any mother or any parent do that looking at the best interest of their child? Mm-hmm. But yet she was made to do it. Okay, so I was on the video conference call today and I asked them the same question as well. So I clarified with them. So what you're saying is you cannot treat our granddaughter if we cannot agree to that same treatment that Lower Hutt was doing. He goes, that's exactly correct. Then we see no other option but to discharge because you're saying you can't treat it. Okay, he breached his code of ethics by not turning around and getting another doctor in place because that's what he's supposed to do under his code of ethics. None of that was done. He accepted the discharge that day, and then he wrote an email to Emily to be able to give to the courts, which was on the affidavit, to state neither myself nor my daughter should be able to have any medical input to decision-wise. Okay. 8 days later, he turns around and he writes to Emily and says, what if I'm wrong? What do we do if I'm wrong and I can't prove it was medical? Okay. 8 weeks after that, he gives another communication to her stating that he now believes that no whānau member is at fault. We have all of this documented as evidence.
And the diagnosis was failure to thrive.
No, that was not a diagnosis because the child I had confirmed by... When they were trying to get her to have this infundification, which is a surgery to tie off the top of the stomach, okay, I spoke to Professor Will, told him that child had eaten orally before. And as soon as I brought that up, he refused to do the operation. He said, without the whānau giving their consent, he goes, or wanting to go ahead with this, I'm not prepared to do this. I've just been told this child has eaten orally. This infundification is only for a child who has not eaten orally. And yet OT were backing that as well. As far as I'm concerned, we've had to stand behind our daughter for a year to be able to help our granddaughter not get invasive surgery because that's what OT wanted to back.
Now she's having to go through physical abuse.
And now she goes through physical abuse because of where you guys placed her.
Yeah.
As far as I'm concerned, I look at it from this point of view. Okay, your act may say that you're not held accountable, but I have specific evidence that shows accountability. Okay, and once this case is finished and she gets her daughters back, I'm pursuing personal private prosecutions as well against any person who's been involved in the case. Because it's just wrong what's been done.
And you should know you're the one that uplifted her.
You were there that night.
So your statement about the S178 brackets 2 and the safetiness of me being around my daughter, as well as the attachment, you're just going on about that about me. Where has there been any concern raised when we were admitted on the 3rd of March all the way through till now? I've had nothing but supervised, but yet your guy's caregiver does that to my daughter, and yet she's deemed safe the first time, and now it's happened the second time, and what are you doing about it? My daughter's scared because of it.
I just wanted to put something in there. A while back, I think it's a few weeks ago, my boss with Jen and Emily. So I think it was with Jen. And one of the things that came forward was the fact that I've been involved with this case for a long time. I've been doing the access, also, and so I was able to watch the relationship and all the attachment type stuff. One of the things that said would they consider a report from me, and I think that was supposed to go back to the legal team, but nothing ever got fed back. So I suppose I'm just sort of putting it there as well, because if we're thinking about the attachment relationship, then I believe it's quite secure. And there's enough evidence in the access reports, even throughout the time of Jess through and all that sort of stuff.
So what you asked of Jen was a social work report on the attachment and parenting styles you've seen.
They're saying, we need to have a psychological report. I knew that when she was referred to mental health, that she wouldn't meet the criteria because I worked mental health for years. You've got to meet a secondary criteria, and there's no way it's the primary. In terms of attachment, that's one of the other areas that I specialise in. So I suppose I'm aware that it's Rebecca requesting that sort of stuff, but probably also having awareness that that's something that we can feedback on. Plus there was a time there where other people that I worked with did some access as well, and so there's enough feedback from them in terms of the questions that are being asked. That's all. But so that's just something I want to put out there, given that it was requested in another meeting.
Something else you might want to bring up with myself and my partner put in for a Section 125, okay, and Oranga Tamariki has not responded with a notice of intention to appear, and they only have 7 days to do it, which ended yesterday. Okay, so each time that something is put forward in the court, Oranga Tamariki think it's all right to drag everything out and think that it's, or seem to think that they can delay what's going on. Okay, my answer to that is this: if they don't turn around and bring it, like we've already been made a party to the case now, okay, so if they're going to try and muck us around again, I'm filing in the High Court. Okay, I'll take it out of the District and Family Court and I'll bring it into the High Court where evidence has to be heard, because at the moment, this whole case, and I know this from what the judges put out as minutes, my daughter lets me look at it because of the fact that I help her, okay, so I help her with all the legal side. Okay, so going by what I have seen come through, okay, Oranga Tamariki are just trying to delay what's going on. They know they haven't got a case, okay, but the problem that we've got is at one stage we had an email in regards to unsupervised access. There was only 2 things that she had to worry about: transportation and the fact that Emily kept on saying there is tension between the 2 whānau. Yes, there is, created by OT. Okay, OT keep creating that tension. At the Huia whānau, when you guys were not in the room, there was no tension at all. We just discussed it and decided what was okay. The problem is OT didn't want to hear it.
That you were part of that whānau.
Yeah. So we all had agreements. The minute they walked back in the room, and there's whānaus have come to an agreement. The amazing thing for us was we were expecting to get hold back from the paternal whānau, but it was actually who came up with everything that she wanted to happen. We were quite happy to agree to it. OT walked back in the room and went, no, there's no way that's happening. So I'm just, for myself, and I think for my whānau, I'm getting to the point where sick and tired of being mucked around by OT, been through the system myself, know how it works. So I'm going to do the best I can to get my granddaughter out of that system, because you guys, unfortunately, you may not intend to do it, but you act in a harmful, abusive manner to any child. I've seen it myself in a family home myself. Okay, I've been in there. You're not making it easier for the mother and the child. You don't work together with the whānau. Okay, I can honestly say that with Emily as a social worker, when you look up on the Social Workers Registration Board the 10 competency standards, she didn't have any of them. The way she dealt with our whānau, she had none of them.
It's a legal uplift.
Yeah, and that warrant that was dealt with that night, okay, after reading up on it, was done illegally. Okay, you cannot come into a house and take a child without first, number one, you guys didn't execute it, the police did. The police officer handed that to me. So you guys didn't execute it. Okay, based on that, he was supposed to check that child and believe himself that the child was at risk. None of that was done. So that's another thing I'm going to pursue. You know, I've been through it when it was SIPS and that, and I thought it was bad enough back then. But to experience this for my daughter and for my granddaughter, you know, there's a lot of whānaus out there, they go by hearsay. Okay? And yes, I go on Facebook and I help some of the other ones out there put their cases together. So, because some of these people should just not have their children taken off them. I'm not saying there's not any that shouldn't, because there are some at risk. But when my daughter does nothing wrong, decides to remove her daughter from a situation where she keeps going down a way, I mean, the medical team had that child at Lower Hutt borderline hypoglycemic every single day. Something she had never been through. When a doctor or a nurse can walk into a ward and a child goes like this, ready for a pinprick test, okay, that's just, to me, that's just unbelievable. No kid should be going through that, especially not one that's 2 years old.
So I will not be stopping until I get my daughter back the legal way. I'm not going to stop. So if any of you guys from OT think I will, you can think he thinks I'm not. My daughter needs
I don't care if we end up having to take this to the Supreme Court. We will do
I
it.
will do whatever it takes to get her back legally. I do not care.
You know, we come to this meeting today just simply based on the fact to find out where you guys were heading with it, because that is our plan, is to, depending on the court case where myself and my partner go through, okay, I'm only going to give the judge one option that day, and if he's not taking it, I'm going to the High Court.
So I'm sorry if it wasn't clear in the email, but the purpose of the hui wasn't for us to tell you where we were at. It was purely for introductions and for you to tell me Oranga Tamariki, us, what you want us to know about your life.
Okay, the easiest thing is then, are you guys going to do our orders to put into the court to return her to her mother?
So,
Are you guys going to make an application to the court on behalf of Oranga Tamariki and return her, which is the same thing I asked Dean?
do you want to talk about what our discussions have had around how we want to work with the father?
Yeah. So first of all, I would like to say that I'm really pleased that your father is fighting for your mokopuna, because I've handled a lot of cases, and I'm not saying most or all, but some of the cases that I'm really frustrated about is when the parents are not doing what they're supposed to do, or just disappearing the face of the earth, and me chasing them to have access with their child, or chasing them and ask them, why are you not responding? Why are you not responding to the court documents that I'm putting through before the court? So I'm just saying that I'm really, really glad that I can see a whānau that's very passionate about their baby. So I'm Marina, and I can say that, like, I'm the saddest cases that I encountered are those children who they're both mom and dad are not there, and they're just in the care of non-kin caregivers. As a social worker, what I always want and working towards is for the children to return to their families.
So you're going to return it?
That's the goal.
No,
That's
now.
the goal.
That's not what we're asking.
At the moment, I don't know enough to return a child to their parents. I just came as a social worker.
Okay, so I'll just say this to you.
I'm just saying that that's my goal.
Mm-hmm. I'll just say this to
For
you.
working
We've got
this
two
way.
options. We can do it through you guys, or we'll just do it through a judge. We're not going to muck around with Oranga
I
Tamariki
want to
anymore.
work
Simple as
with
that.
you.
I've had enough of trying to work with
We're
you.
not going to work with Oranga Tamariki. We've done that, and it's got us nowhere.
And I know it's frustrating.
You're saying you don't know enough. That's not our problem. That's not my girl's little
But I'm
problem.
telling you that
She
I'm
needs
willing
help.
to know more.
That's
And I'm
not our
willing to
problem.
work
What
with
you're
you.
telling us when you say that is this: I'm willing to look at it over the next few months, and in the meantime, my granddaughter gets beaten more by the grandmother. Sorry, no, not going to happen. If I have to, I'll go to the High Court.
You can't
She's already been put in
be,
too much danger.
beaten by the
She's
weight
been
line,
hit
and you
6
doing
times
nothing.
last year, okay? Again, only 2.5, 3 weeks ago, okay? And you guys still deemed her safe. How ridiculous
Why
is
is she
that?
in that house?
I tell you now, if it was anyone else and they didn't have a caregiver and it was a normal whānau, you guys would be uplifted.
Exactly.
But because she's in your care, Oranga Tamariki are ignoring the fact that it's going on and trying to cover it up. I've looked up your Triple P parenting course, okay? They only do online. I run Youth Horizons. They have no idea what you guys are on about. There's no course that a child caregiver that's from OT can do that's assaulted a child.
Your guys
You can
say
call it low-level violence. Here is what it is. It's Section 194 of the Crimes Act. It's called assault on a child. Okay? Move to Section 195. Anybody who knows about that assault is also accountable for it. So that's why I'm saying, when it comes down to it, I've got no problem filing private prosecutions in regards to it. It shouldn't have to go that way. Do the right
You're
thing.
one of them.
Do the right thing.
I think
That's all you got to do.
also that's the key, is that there's a lot of frustration here because it seems to have taken forever for the whānau. So this is what, you know...
It's because OT back out on what they say they're going to do. That's what the problem is.
You know,
We had a meeting, a hui whānau, everybody came to agreement, OT stopped it.
I mean, I've heard what you guys have just said, and while I can appreciate your frustrations, you know, with full intentions to humbly work with you as the new social work team. Take that as you may, and I understand where you're coming from and your rationale, but we would like this opportunity to work with you.
Okay, I'll put it a different way to you. How long is your goal going to take? 6 months, 12 months? How long does that girl got to keep getting beaten? She's 3 years old.
Are you going to take her out of the household?
That's what should have been done ages ago. She should have been moved from that placement.
So there is a current caregiver investigation.
It's
Whether you've been sent an email by Carolina.
Yes, but that's not good enough. It's
No.
happening by the same caregiver in the same household, and you won't even move her. So she's in that household every day. When she comes to contact, she's happy to see us and everything. She hates leaving. She always asks, even like today in front of Phil, "Oh, Mum, come." "Oh, sorry, darling, I can't." You're not the one that has to go through this. It's bad enough that I feel the way I feel, but imagine her, what's going through her head.
Can you tell me what's going on for you and for these are happening?
I want my baby back. That's all I have to say. Give my baby back to me. She'll be safe. She's happy. You can't do anything else other than give her back. Anything harm goes to that baby, that's your wife's fault. Just remember that.
And considering the judge has said, okay, the only thing he's waiting on is to be able to do the discharge, okay, and that is being held back by they haven't got any dates. This is why myself and my partner, that's it, we're getting involved, we're going to file, okay, because I'm getting sick and tired of our daughter and our granddaughter having to go through this. Okay, you guys are allowing our granddaughter to be abused, and in the same time, her to be emotionally abused, knowing her daughter's been hurt, certain that it's frustrating for her every mealtime, okay. I informed my daughter before September last year, 3 weeks before you guys came out with the report of concern. I told her daughter was being hurt. And she asked me, "How do you know that?" And I said, because my mother was exactly the same as how your daughter is being hit, and I would not be surprised if it's on a daily basis. 3 weeks later, report of concern comes in, she's being hit. Okay, I said to my daughter after that, okay, they put down one hit, okay, it's not happening once, it's happening more than once, and it will keep on going. Then we get it back from the New Zealand police. I find it quite disgusting that New Zealand police and Lower Hutt courts state that things get dealt with differently just because OT is involved. Okay, that is a statement that came from the Child Protection Team officer and the registrar at the Lower Hutt court, because I mentioned it to them. Oh, things are always dealt with differently when OT are involved. Why? Every other person would be charged.
Can you ask that question?
What was that?
You asked that question?
I've asked that question of...
Can we just go?
So we're talking. We want to be creative in how we work with you and get ultimately to the goal of a return home. Like Ken said, that's always our aspirations as social workers. So what we're going to agree to you today is that we need to go back and talk with everybody. That's what we do. We work in collaboration with OT. So we're going to find out the current care and protection concerns and what has been addressed, what hasn't been addressed, what are the care and protection concerns, how can they be met, and if they were met, the timeframes in which to reach your goal. And we will get that to you by next Friday at the latest. And then from there, we can organise another hui to discuss
No,
this.
it's another hui.
No, we've had enough.
It's either here's part of the case note that Emily wrote up. You read that, okay? Now she
That's
states
from your
there.
OT file.
That's from your OT file. She stated at that stage that's the most ill she's ever seen a child. That's what I was bringing up about. Okay,
And if you're
and that's
not
under
custody.
the OT custody and caregiver. The other thing I want to raise once you've finished reading that.
So who is...
She's the community nurse. Now the other thing I want to raise with you guys is this, okay?
Bearing in mind with that, I ran through to Wellington Hospital myself, trying to arrange to get my daughter seen there ASAP, and that's following all of that. So while they're saying, well, you know, we've got to see what we can do, I'm running through to the hospital saying, well, my daughter needs to be taken in ASAP. Then what does the caregiver come back with? Oh, after her nap. Her nap is usually in the car. Her being seen by a medical professional to get treated when she's in that state is more important.
And the fact that when she arrived at the hospital, she was diagnosed as clinically dehydrated. Okay, not dehydrated, clinically dehydrated. Okay, so not much further, and she wouldn't have had dehydration in her to stay alive. Yet her caregiver, that you guys approved, thought it was all right to leave her asleep until such time as she woke up, rather than dealing with it urgently. Okay. The other thing I want to bring up, that caregiver wants to take that child at the end of March, 27th of March to the 4th of April, up to Auckland, where we know COVID's going up and down all the time. Okay. My daughter has already put in for a guardian dispute on that. Emily obviously thought it was quite smart to come back and state, because the judge had stated that he could not rule on the grounds of it, okay, that they were going to allow her to go anyway. That is not what the judge stated at all. What he stated was this: I cannot deal with it on a without notice basis. The other parties involved in the case have a right to be heard, so this would have to be on notice. And as I have brought up with the courts, for a judge to turn around in the second paragraph and say, and even if I'm wrong, which means he's not sure of the law, okay, that it would have to come back into court anyway. So what I'm going to tell you today is this: if Oranga Tamariki is not going to stop that happening, because we are now parties to the case, I will file a dispute for it and an interlocutory injunction to stop it happening. Because the child's health is more important than someone wanting to go to Auckland.
And I've already stated I do not consent to her going.
That and the
I've
fact
made
that
very
that caregiver keeps assaulting her. So how do we know what's going to happen to her up there? So if I have to, I'll file an interlocutory injunction for 14 days to stop it happening.
And I'll be filing the guardian's dispute.
You have no
In addition
consent.
to the one you've already made?
Yes,
Yeah.
because it shouldn't be happening.
Okay.
OT is letting that lady get away with far too much, and in my opinion, from the records and everything I have seen, because I help her go over them, okay, too much cover-up going on. I see it in the actual OT file. I see it in the doctor's file. Okay, the two, OT and the hospitals, are colluding together to hide it. And so I'm not going to allow that to happen. If I have to, I'll bring it public.
Carla, you've been to Nanny or Nanny, Grandma?
She's Jemima's nanny, not grandma, because
I'm not your grandma.
Jemima knows nanny, and then grandma. She knows grandma smacks her, nanny doesn't, and nanny never will.
So, Nanny, I mean, I haven't heard much from you, so I'm just wanting to know a little bit more on your perspective of
My
this.
perspective is you need to give her back. That's all I want. Not this, month's time and that. We don't want anything else, but you just give her back today.
It's really that simple. Give
What
it back.
support will you provide? Jesse?
She lives at our house.
She lives in a house.
We are in this together.
Yeah.
It was
Whatever,
me
I know
that
they know
provided
what
the
they know, I
homemade
know.
shake.
Why don't you think about, instead of us
about that caregiver that's assaulting you.
That's the thing. You guys have got the care and protection concerns in regards to our whānau, okay? But as I've listed in court, Section 14.1e, Section 14AA1, Section 14AA2b, 2a, 3b, 4a. She's in need of serious care and protection. Section 5 under your own Act through the Unicroft Act, okay? There's Section 4a, okay? Where's the safety of the child is paramount? Like I told Dean Weebly when I went into the office. There's no safety of the child is paramount, okay? I don't care how many laws I got to bring up, and if I got to take it to the Supreme Court, I will, okay? Because our granddaughter is being abused under your guys' care. And the way I look at it is this: yes, but you guys are the custodians, okay? And whoever the social worker is that's working on it at the time, they're responsible, and so is the supervisor. So I understand why Jen has jumped ship after being in court, okay? And OT can say what they like, but until such time as my daughter turned around and said to the judge, well, I don't understand why they need more time, Your Honour, because the supervisor that's there has been the supervisor the whole time. But that's a clever move to jump ship and get off it.
So when we identified who could take the only person and the most senior was you.
So why was Jen gone? She knew the case.
I'm not Jen. Jen is not my supervisor.
Yeah, so
why is she gone?
Jen isn't gone from our organisation. She's currently on
So why is she not doing this case?
Are you trying to say that each social worker has their own supervisor? Is that what you're trying to say?
Yeah.
Okay. As long as you guys understand, okay, that the longer this carries on for, okay, the longer the notes will keep going into your system, the longer we will keep getting them, and the longer, the more accountable you'll be held. Okay? I don't care what your act says. Okay? Under your own names, you're prosecutable. Okay? There is so much in that file that has been supplied in bad faith, okay, that is prosecutable. So as long as you guys realise that, okay, I understand Emily was there first, and Emily may think by leaving your organisation she's gone and she just has no worries, well, she's wrong. Okay? So I've already looked into all of this, okay, because when all of this started happening, you know, I knew that none of it was right. I just didn't know why it wasn't right, okay? And I've looked through Care of Children Act, the your guys' whole, what is it, 400? I've done all the research. You know, I know the family court rules, the high court rules. Yeah,
as you would when you're fighting for your mokopuna.
The thing is, there's no need to fight when you've done nothing wrong. You refuse to give it back. It's as simple as that. So
we're not going to keep going through meetings or FTCs or anything like that. So we'll make that clearly understandable.
So, I mean, like I said when we came back into the room, we agreed that we will get back to you by Friday around the questions that you've already asked of us, and that's all we can do. Okay, in terms of those questions,
it's not all you can do.
Yeah, right now, I can't give you the
Are
answers.
you going to give her back?
Our goal is to return home.
Are you going to give her back now?
We don't want to hear about goals.
No, we don't care about goals. Are you going to give her back?
Like I said to Dean, it's as simple as filling out a bit of paperwork and filing it through the EG system.
We're asking you right now, are you going to give her back?
And if you're asking right now, is Jemima coming back into your care today? We can't do that.
That's all we need to know. From there on, we go to the court. That's all we need to know.
We're not working with you guys anymore. You two may have only
You
come
cannot
on.
wait until Friday next week.
No. There's no waiting. I know.
We're not going to wait at all, okay? When it comes down to it, it's already in court, okay? We were only coming here to see where we move next, okay? To give you a bit of an update, okay? We've already been on to High Court, Supreme Court to find out what we need to do, okay? So coming here, if you weren't willing to do the paperwork to return, okay, then we go to the court process. It's really simple, because you guys, at the moment, as an agency, are causing that child more harm and abuse than what she's ever was ever going to get with her mother, because her mother's never done that.
And I understand that you may have only come on now, but your guys' organisation as a whole has had more than enough chance to do the right thing by my daughter. But no, you choose to go along and put us through more every single day.
Would you let me and Keisha speak to practice leader?
Are you talking about Dean Weebly?
Because me
practice
and
leaders.
yes.
Who's that?
Leo.
Okay. So anybody within your guys' office? No. Okay. Why? Because Dean Weebly, 9 months now, that if our whānau or anyone else calls in regards to our case, okay, reduce it back down to the site manager so he can deal with it. So no, we're not going to let it get hidden within your office, because that's what's been happening. We have proof of that. This is the thing. I don't know whether you guys are aware of it. If you haven't read the file, you're probably not aware of the fact that Dean has hidden so much. Okay, we've been to government level. Okay, ministers. Okay, and it all gets pushed back to Dean because that's where he wants it. So if he wants that, fine. He can take on the charges too in a private prosecution. Because he should not be doing that. Like the lady that pushed it back to Dean because that's what it says on the system. She said, no, I want this to be dealt with up here. I want to deal with the head, not the hand.
So from my daughter's case, what are you aware of? What do you know about our case?
No, that at this stage there are the applications before the court that we need to do for the notice of intention to appear.
Well, you've had your time on that, and I'll tell you right now, if they come back to me and ask me, are we going to allow it, you will not be getting any more time. You've had 12 months.
So we will be responding to that, and we will be filing our notices of intention.
It's too late.
But how are you going to do that when it's too late? Because they've got to ask the permission of us.
We can still apply.
You could apply, but that's with leave, and I won't be allowing leave on it.
We can still file those notices of intentions to appear, and that's our intentions of doing that. But before we signed our names to that, we wanted to meet with you.
So what else are you aware
So hold on a
about
minute.
the case?
So knowing that, and knowing that it had to be in by Wednesday, why didn't you make an appointment before the Wednesday?
Exactly.
So to me, there's another delay on purpose. Because you knew it would have been Wednesday, because that's the 7 days you had, but you've decided to meet Thursday, pushing it out further.
I did give a number of dates and days and times.
This was the earliest one that you gave.
So that's past the time for a notice of intention to appear, which is why I've asked the court what's going on and that I want to put through without leave.
Which is why I asked.
Because you guys are not entitled to keep pushing back on whānaus all the time like this when you know you had a date. You know, the minute that she had done that, OT was the first one in going, no, she needs to have her evidence in. And yet they want her to give them time.
So what else do you know about our case?
They don't know nothing.
That's the thing. I think you come here too unprepared.
Well, I'm asking
to talk to you. I've read some documents on the system, but it's just documents that's written on the system. It's just social workers and other professionals who's written that. I really want to know for myself.
So what have you read? That's the question I'm asking from the file.
One of the things that I can remember from the file is that the medical professionals advised the advice from the medical professionals are not being followed.
So you're going right back to 2019.
Yeah, I'm just that's what I can remember.
But what I'm saying is for you to be able to go back that far and not still understand it, tells me that you haven't read up properly. Okay. I understand that I've been involved with it for a long time, but like I say to everyone, okay, if you're gonna turn around and tell us you're bringing yourself up to speed, at least come being up to speed.
Why make a meeting if you were up to speed?
That's the thing.
So the agenda, and I'll refer back to my initial email, the purpose of this hui wasn't for us to tell you what we know. It was for you to tell us what you wanted us to know and us to actively listen.
But we've already told you
that, and you're saying no.
Stated in your email that you need those couple of days to bring your guys' selves up to speed, which clearly you're not even at the start of the gist of it. You don't even know much at all.
You guys have all spoken in detail around the things that you've applied for in court, the applications that have been made, the memos and the communications that have gone by different people via different avenues. What you're asking us to achieve is a huge feat. And we both have competing priorities. It is impossible to read up every single thing that has happened in this case.
It would have
You
been
should have put it in
impossible
your
if
email
you
that
guys
you're going to come up to
didn't
speed.
create it.
I mean, if I can turn around and help another person and look at their case of 2,000 pages and help that person in 4 days, you know.
And we still remain, and I will repeat myself as many times as it needs in order for you to trust what we're saying. We want to work with you.
Yeah, well, I'll tell you this
The
right
problem
now.
is wanting to work.
The trust is broken.
Yeah. And the wanting to work is not going to happen simply because you guys don't do that.
I respect that, and we want to get that back.
But you
Never going to
can't.
happen.
No, we've had enough.
All I am here for is to get my daughter back. No time frame, no, transition, no nothing. Just give her back where she should be, and That's the thing I do not understand about you guys and your guys' organisation. How can you even do your everyday life, sleep at night, knowing what my daughter's going through, let alone all the other kids that are going through the abuse through OT, and yet you think it's alright just to go along and go, oh, we need to do this, we need to do that. Did you think about that before you went along and took the child and put them through that? And still continue to leave that child in an environment where they're going through that?
She's in danger right now, and you're doing nothing.
We're telling you she's in danger, and the thing, I've seen your story that came out in the news, okay? So I don't understand your way of dealing with this when it is, I know I've listened to the part about your upbringing and that you thought you could do a better job as a social worker. All I can say is in this instance, maybe you should think about that again, because it's not happening. I've been through the system myself, okay? I would never want anyone to go through it, okay? I would never take on a job as a social worker because I know what the system does, okay? I understand your way of thinking, but unless you're going to move in the opposite path to what you've been in, then you're never going to make a difference.
You're not helping that little girl, I'll tell you that now. And she's got no voice.
I mean, if I think back to when I was in care, okay, if someone was telling me that I had to stay away from my parents for another 5-6 months before I can go back, okay, then I would be looking at that person as being very evil, okay? And when it comes to it, if you've been through it yourself, you should be able to see it from the point of view I'm putting across, because I've been in a family home for 2 years, okay? And there's nothing worse than being held back from your family. That's the part, like, I came today knowing that when that uplift happened, okay, and I saw that you had been part of it, okay, I looked up by social workers and I thought, okay, maybe we got the wrong social worker. Maybe that one might have been a bit more compassionate about it, dealt with it differently. Sorry, but today is telling me I'm wrong. And so to see that story, I thought, okay, there might be something. That's why I thought, okay, let's go along. I mean, we've got a supervisor that's been through it herself, so we should be able to get somewhere here, but we're not. So I'm sorry, but that's my outlook on that story.
You're not going to give it back, there's no use.
There's no proof. You guys don't have any proof of what has happened, okay? She's never actually done what is stated, okay? The child was in hospital 3 months with a doctor doing and it was me that turned around and said yes, I agree with you, the child needs to stay in hospital. Why? Because that doctor and that caregiver are not capable of doing anything. Okay, you've proved it. You've had her in here 3 months and you still have her going downhill. Okay, it wasn't until I said to get her onto soy because she was flourishing on soy. And then 3 days later, finally Dr. Wilson said yes. 3 days after that, the vomiting stopped, which we knew was going to happen. We just had to get someone to listen. The problem is OT and the doctors don't listen.
And that's the thing, you're quick to sit there and try and find any fault on mine and my whānau side, but where the fault actually is right before your eyes, you choose to turn a blind eye to it.
I just want to say something to what you just said. OT don't listen. That's what you said.
That's right.
Our whole intention of coming here today, and I'll repeat myself, was to actively listen.
Yep, that's fine. But you've got management that won't, so you're never going to get anywhere. Okay? When you've got a site manager that purposely is trying to hide everything, you turn around and sent him the form, an actual waiver form signed by, okay? He talks a load of crap when he says you guys don't know what it looks like. Well, that's a load of crap because you guys have to get copies of the affidavits. She signs those. So you have the signatures on file.
So you're...
Not only that, there's been multiple privacy waivers I've done for media since this has happened. That's the first ever time I've done a waiver thingy, and yet they've said, oh, we need confirmation. No, you don't. There's plenty on your guys' system. Look, you'll see
Dean's
it.
just trying to push it.
If I don't want it, why would I fill it out?
Exactly.
A privacy waiver?
Yeah, and I've done how many for RNZ, other media agencies, and yet nothing comes back like that, and especially from Dean. He never emails me. And to turn around and say that, no, you don't need confirmation from me. It's in my signature. Why else would I sign it? Why else would I fill it out?
And your site manager has got to learn how to do his job properly, because when you turn around and you contact people and you state that you've turned around and emailed and phoned them, okay, you got to make sure you have. Okay, it's like our experience this time, not back years ago when I was younger, but this time, okay, is this. Okay, Dean and Emily, okay. No, you tell me this. How does a client work with a social worker when the social worker says, I don't want contact with you? Okay. Follow that up with the site manager saying, neither of you to contact the social worker or myself. No. Dean said to us, okay, he's got a habit of doing this on phone calls, okay, that Jim could not communicate with Emily. All right? Then it came back when he rang me. Neither your daughter nor yourself are to communicate with anyone in our office. Okay, you are only to communicate with me, which is Dean. Fine, put the communication through to him. How do you communicate with someone when, like I said to him when I came into the office Monday last week or the week before, how can someone communicate with you when you haven't answered an email since the 10th of April 2020?
So your preferred method of contact is always and will always be email, or
we look at it from this point of view. Yes, the email is there, but there's no preferred contact because of the fact that there's no contact needed if the child comes back.
And that's the thing when it comes to advocating and trying to do the advocating for us. He is joining my support network with my father, Marie South. He's not talking on our behalf. He's joining us.
But the problem is Dean seems to think it's all right to step in and go, well, we've got this privacy waiver and we don't know whether the signature's right. Paul, you've got it on file. How many times, from how many affidavits, how many applications came through the court? You've been served with them all.
I suppose what I want to say is that it's clear that the relationship between Oranga Tamariki in the past and the whānau has been marred by lots of stuff that probably we should say shouldn't have happened. And so it's come to a point where, in terms of their own safety, also doing things by email is safer because at least you've got the information there rather than over the phone. You know, so I know that you guys are coming and saying, you know, trust us, we're going to work through this, but this whānau have been through such a lot of stuff, and the times that they've attempted to do and create change, they've pretty much gotten the slap in the face, you know, in some ways. And so, and that's why, you know, I suppose what I'm hearing is, where are the whānau at? They're at a point now where they're saying, if we don't get our granddaughter back, we need to take the legal route because that's the only way it's going to happen. Regardless of what you guys are wanting to do, the thing is they've been through quite a lot. You know, even just the short time that I've known them, there's been some stuff there that I would go, whew, is that really actually fair, and is that really actually something that should happen? You know, as a social worker, I'm a trained social worker, attachment and family therapist. There are some things that, as a social worker, I would go, that's just not appropriate. Yeah. So I can see why they're at where they're at as well. So there's a lot of stuff, and I can see how sometimes it can look lucky, but underneath it all, there's some really clear evidence, and that it says something needs to change. This father needs to have their child back. So yeah.
So like we said when we came back in, we will get back to you by Friday at the latest. What you guys decide to do, we can't control. We would hope that you keep to the expectations that are in that initial email.
By the email.
Yes. And so, in terms of the notice of intention to appear, we will be filing and we will be opposing that because our goal is to return home. One thing I do want to say to the grandparents is that if we were to support that, that would be ultimately undermining what Jessica's goal is.
Undermining what goal?
Well, because the goal is for Jessica to have her daughter.
Yep.
But supporting an application where you're wanting.
We're not asking you guys to support that. We're like I said, I've only made the application in the court, knowing that the judge is probably going to turn it down, so I can take it to the High Court.
Oh, okay.
Okay.
They
because
fully support me having my daughter back, having their granddaughter back in our house.
Exactly.
Oh, okay.
So the like I say,
that was the intention. Putting it not for.
We're applying for the discharge, yes, because if the judge is going to go ahead on the day and discharge it, that's good. Okay, but if he's not willing to discharge it, this case has been mucked around in the family court for far too long by both, lawyer for child and OT.
I understand your position now.
Yeah, it's about time, in my view, that Oranga Tamariki stood up and did the right thing for a child. There is absolutely no reason. There's no, like the care and protection issues that were put in place. Okay, I can honestly say that the application I filed, has way more care and protection issues, and it's under Oranga Tamariki care, and they're worse issues. They're actually worse issues. Yeah, you guys are allowing a caregiver to beat the child.
These are the concerns you have with so
Yes, and they're not concerns. They're not allegations like everybody keeps trying to say. The woman has admitted to them. She's the one who informed police, I hit the child when they went there. You guys, as an organisation, are the ones who tried to hide it, saying she got hit once. Then she stated, no, she had told you guys this child's been hit 3 times. Okay. Then it moved on to the police and it became 6 times. But hello, we are still able to, as an agency, deem this child safe in this care. How do you deem the child safe in the care? You've got multiple accounts of assault on the child.
And it shows she doesn't want to be there when she's sitting there from the medical records and everything that I'm receiving. It says in there she has slapped across the face. She's never ever done it to any side of our whānau. And that she comes into contact and everything, and not once has she done that. But yet she does it over there.
And the thing you have to take into account is this, okay? The only reason that you guys have got as far as you have in court is because her lawyer, when she had her, didn't submit what we wanted submitted. Okay? We have made the judge very well aware from professional files what has gone on with this case. Okay? This is what I believe is the reason why at one stage the judge asked lawyer for child to get the medical file and pass it around the professionals so they could get a good view of what had actually happened. Not what OT was putting forward and what the lawyer for child and that was putting forward.
Which is
So
why OT
this is why I say to you guys, you guys should not have come to a meeting unprepared, knowing fully what is on your files and affidavits.
look, what I do, what I see is a whānau that's hurting at the moment. And we can carry on repeating and saying the same things. And unless we prove that to you, that healing between the two can't happen. So unless there is any other information you guys want to share, I don't want to keep having to repeat myself and saying the same. I'll rather just do the mahi.
Do the mahi and give it back then.
Exactly. There's no actual work to do. It's a form. It's a simple form.
Paperwork.
And like I referred to in my whakatauki about the uniqueness of the child, I think we're all in this journey together. Yep. We might be going down different paths and have different views, but we're in this journey together, and the person at the centre is...
Yeah, the person at the centre that you're hurting on a daily basis.
And Jemima, a huge whakapapa. She's got whānau on both sides.
Yeah, but one side that actually does care about her to the full extent, which shows when she's over there being abused, the father's over there living in that house on a daily basis, and yet what does he do to protect our daughter?
So how I see this, if I'm thinking metaphorically right now, is that right now we're like steering the oars in different directions. We need to get on the same wavelength. And how that looks moving forward, I think we're just going to have to be navigating that space together and building that trust up. We need to do our mahi, and so do you, and you guys have been doing that, and your advocacy is on point. And I just reiterate without...
Looks like we're getting nowhere now.
Exactly.
Looks like we're getting nowhere.
You guys are obviously trained in the same thing, because Dean came out with exactly the same wording. So we'll just end it here and we'll file it through court. Okay?
Yeah,
because we're obviously not going to get through with you guys either way. And going by what I've heard today, okay, you guys are still happy to leave our granddaughter in an abusive situation, which is not what we're not going to allow that.
You may not have read it in the file yet, but we have told you in person today what she's going through, and yet
you do nothing.
And I'll just reiterate that if that child goes to Auckland, I'll be seeking orders to be brought back.
Goodbye.
So, yeah, there's, like you say, there's no use talking anymore because you guys have your way of dealing with things, which is wrong, but yeah, we'll deal with it the legal way.